Ms. Enix that day. He uses that ATM card first in Tennessee and then in Ohio, and he is stopped in Ohio in a car with the daughter with him. The state also introduced evidence claiming that Mr. Enix had been sort of fabricating evidence in advance by typing information into his phone about assaults from Ms. Enix that the state argued had never occurred. The state claimed that the real problem was that Ms. Enix had moved on, had begun a relationship with another man, and that Mr. Enix was not able to deal with that. I just want to outline again, I know the court has read the briefs, but I want to outline the defense theory because I think it does play into the issues raised on appeal. The defense.
Mr. Harwell, let me ask you this to begin with, because I was a little bit confused in reading your brief. You're not denying that your client committed this homicide, correct? You agree he committed this homicide?
Yes, and that was
just a question of premeditation.
Yes, it was acknowledged in the opening statement that he had been the person who stabbed her 47 times.
Okay.
So as I said, that was not the issue. The issue was premeditation, in particular, the part of premeditation, the statutory language of whether Mr. Enix was, quote, sufficiently free from excitement and passion as to be capable of premeditation. And that was the whole essence of the defense. Not that he didn't do it, not that he didn't intend to do it, but that at the time he did it, was he sufficiently free from passion and excitement such as to be legally responsible for premeditation? Or in particular, to phrase it correctly, had the state disproven the existence of excitement and passion such as to make him capable of premeditation? In support of that defense, the defense did introduce a number of facts that could be relevant to understanding what could have happened in the house or in the apartment. It clarified that Mr. Enix was still going over to the apartment on a regular basis. It clarified that Ms. Enix herself was a somewhat volatile individual, had been charged with violent crimes herself in the past. The defense pointed, in fact, to the sheer number of the stab wounds, which were excessive, claiming that was indicative, perhaps, of passion. And defense closing argument was, yes, this happened, but what happened? There was no thought, just emotion, just raging emotion, no thought, no plan. As a defense closing argument.
Would your argument be different if, and just out of curiosity, 47 times? And I hear a lot of cases where someone is shot. One of the pieces of evidence that a jury can rely on is the number of shots in terms of forming premeditation. I mean, could the same sort of argument be made here that it's like shooting somebody 47 times? Is that not a valid argument for someone to base premeditation on?
So I agree that's a relevant fact. In my mind, that's a relevant fact that can be spun either way. Premeditation sort of, to my mind, has two different aspects. One is this something that was sort of intended? Is this someone wanting to kill someone? And the number of stab wounds or the number of gunshots certainly goes to, are they wanting that person dead? But also the sort of excessive nature of the stab wounds here, I think, can also play into the idea that this was someone who was out of control at the time that the killing occurred. And so ultimately, the question that was presented to the jury was what happened in that apartment. In particular, could they know beyond a reasonable doubt that when these stab wounds were inflicted, that Mr. Enix was not under the effect of passion and excitement, such as to preclude premeditation? Was there an argument? How did this happen? What time did it happen? What was going on before it happened? What did Ms. Enix do during this argument, if there was one? All of those questions, really, there was no way for the jury to answer. And so the defense theory was, if there is no way for the jury to answer those questions, how can a jury conclude beyond a reasonable doubt that the defendant was sufficiently free from passion and excitement? So I have raised that as a freestanding sufficiency argument, but really what I want to emphasize today is not the sufficiency issue, but to emphasize that is the point that is in dispute. That is what the jury is having to decide. You have this void as to what actually happened in the argument leading up to the infliction of the stab wounds. Can the jury say beyond a reasonable doubt that Mr. Enix was not in a passion precluding premeditation? That's the question they have to decide. It's kind of a tough question for a jury. It is a question of, yes, this man stabbed someone 47 times, but we're asking you to apply this particular legal doctrine to say that he was not premeditated. I think that's a tough
you're
task.
asking the jury to speculate.
I think it's the opposite. I think the state had to ask them to speculate that he was not in that state of passion. We were merely saying it's not proven what state he was in, and in that situation, you can find him not guilty. So I think ultimately,
let me ask you. I assume the trial court charged the lesser included offenses, including voluntary manslaughter. Is that correct?
Yes.
And in that voluntary manslaughter pattern instruction, it explains to some extent what a state of passion is, or at least it uses the term that you're not in that, or you're in that if you're going to be guilty of voluntary manslaughter rather than first-degree murder. And so the jury had that instructed to them, correct?
It did. And ultimately, I don't know they ever got to the voluntary manslaughter instruction, but I'm arguing, I realize I've spent a bunch of time talking and hadn't actually got to my issues yet, but I'm arguing that these issues put a pressure on the jury to not actually consider that fine legal point. The first issue is the introduction of the photographs of Ms. Enix's body. I've included those in the addendum. You can see them in their full scope in the technical record. Very gruesome body pictures showing her body, showing her face covered in blood, showing her eyes open. And 3 or 4 of those were introduced really for no purpose at all. There was no dispute as to how she died. There was no dispute even as to who killed her. There was no dispute as to the nature of the wounds. And those gruesome photographs, I argue, really only had one possible effect, and that is to evoke and inflame the emotions of the jury. And this court and the Supreme Court have given guidance as to restricting photographs from coming in when they serve no probative value on any issue that is in dispute. Because the danger is, as I said, the jury here was being asked to make a fine legal distinction in favor of a defendant that they were deciding was a killer. And when they are also having their emotions inflamed by the evidence, that becomes much harder for them to follow the instructions that they're supposed to follow.
One question about the photographs. I assume there was a contemporaneous objection by the defendant?
It was both a pretrial motion in limine and renewal of the objection at the time.
Okay, because the photographs could, in my opinion, possibly work in the defendant's favor if you're seeking to show passion. You're arguing the 47 stab wounds basically support that argument, and the photographs could do so too, but there was an objection.
There wasn't. The thing I didn't clarify in my brief, the medical examiner testified, used photographs taken at the autopsy that actually show the precise location of the wounds. And those photographs were introduced. The difference between those photographs is those were relatively antiseptic photographs. You can see the wounds very clearly, but you can't see bloodied face and staring eyes. And so I think, in fact, that is a good differentiation between the kind of photographs that could be relevant and those kinds of photographs that are only going to arouse the emotions of the jury. The other argument, again, going to the effect on the jury relates to the closing arguments by the prosecutor. I've identified a number of different issues that we believe were improper. I want to talk just about really 3. One, there was argument by the prosecutor that Mr. Enix had 2 other daughters and that he didn't care for them. He never wanted to meet up with them. He didn't care for anybody. That argument was both improper in terms of it was not supported by the record, and was also improper as essentially character evidence. Whether or not Mr. Enix was a good father to his other daughters, totally irrelevant to anything in this case. There was a line of speculation from the prosecutor in closing argument in which he took just the tiniest pieces of evidence and blew up stories about them. There was a phone in the bedroom that had a crack in it. And that's really all that was known about that phone. The prosecutor said, well, what must have happened is that Mr. Enix tried to get into that phone and couldn't get the password and got the password from Ms. Enix and went into that phone and found that she was exchanging messages with another man and therefore was angry about that. Again, a story that was just made up by the prosecutor. He also said there was a coffee cup in the house. And so he came up with the story that after the killing, Mr. Enix was so calm that he made a cup of coffee for himself. Also, there was an ironing board that was in the house. And so he says, Mr. Enix is so calm after the killing, he irons his shirts and puts them on. Again, sheer speculation and ultimately speculation tying back into whether this was a passionate homicide or not. He's arguing he's so calm that he can make coffee and iron his shirt after the fact. And really, there's no proof that that is what happened. And finally,
Harwell, you're 15 minutes into your argument. I just wanted to give you some time. Okay.
Thank you. And the final part of the closing I want to point to, again, because this ties directly into, is the jury going to be evaluating the appropriate legal test, or are they going to be deciding we don't like Mr. Enix and we're going to convict him regardless? The final point is what was the final words of the prosecutor's initial closing, when he's about to sit down and he says, so in the final analysis, I'm asking you to find him guilty of all these counts. I want you to show him mercy. I want you to show him mercy the same amount he showed Kim. And I think that this court and the Supreme Court have made clear that kind of argument that a jury should be showing the same mercy or lack of mercy to a defendant that they showed to a victim is simply not proper. Here, this clearly was the planned culmination of the initial closing argument. Those are the last words before he sat down with his initial closing. And I hope all of this ties into this same theme, that the jury here had a hard task. The defense was conceding that Mr. Enix had killed Ms. Enix. The defense was saying, you need to look at this evidence. In particular, you need to look at the void in the evidence, and you need to conclude that the state has not been able to prove beyond a reasonable doubt that Mr. Enix was free from excitement and passion so as to preclude premeditation. And that's a hard task for a jury. That's what the law imposes on them, but it's a hard task. But through these issues, through the photographs, through the closing arguments, through other issues we've raised in our brief, the state was seeking to arouse the jury against this man, to arouse them to make a decision based on vengeance, based on emotion, based on anger. And for those reasons, we believe Mr. Enix did not receive a fair trial. And I'll reserve the rest of my time for rebuttal.
Outstanding time management, Mr. Harwell. You have 3 minutes. You sure do. General?
Good morning. May it please the court. Nick Spangler for the state of Tennessee. Your Honors, I'll generally address the issues addressed by Mr. Harwell in the order he addressed them, but I will start by talking a little bit about the sufficiency of the evidence with respect to premeditation, since I do think it's important for the court to keep that at the forefront of its mind when considering some of these other evidentiary and closing argument issues with respect to considering, maybe the harmlessness of some of those, whether they were admitted properly or not, or argued properly or not. And so I'll start with that. And we submit that the evidence overwhelmingly supports the jury's conclusion that the defendant premeditated this murder. He clearly used some sort of deadly weapon to stab Miss Enix an astounding 47 times. Nothing suggests that she was armed during that attack. In fact, what the evidence suggests is that she only resisted that attack barehanded. And what I'd point to for that idea is that She did have some defensive wounds on at least one of her arms, maybe both. I think it was just one of her arms. And then she had some skin under her fingernails that I think the evidence was that it couldn't be tied specifically as defendant's DNA, but either defendant's DNA or some male relative of defendant. So circumstantially, that supports the idea that was the defendant's DNA under her fingernails. Nothing suggests that the defendant rendered any aid to the victim, either by way of resuscitation efforts or calls for emergency medical assistance. And nothing suggests that Ms. Enix provoked the defendant in any way other than by divorcing him, moving on with her life, and dating another man from her workplace. Defendant clearly announced his premeditated intent when he threatened the victim that he would break her neck if she ever allowed any other man around their daughter, which is exactly what happened when she started dating this other man from work. And so really jealousy and vengeance present as the primary motives for this murder. And financial gain presents as the secondary motive, given the defendant took Miss Enix's debit card and used it to withdraw several $100s during the couple days that followed this brutal murder. I want to address the defendant's argument with respect to passion. He proposes that passion is one reasonable hypothesis in this case, and we don't dispute that. The problem for defendant is premeditation is also an at least equally reasonable hypothesis in this case. And the problem for defendant is that the standard of review no longer requires the evidence to exclude all other reasonable hypotheses except for the one accepted by the jury here, which was premeditation. Because premeditation was a reasonable hypothesis, was supported by this evidence, it really doesn't matter whether or not, a crime in the state of passion was an alternative reasonable hypothesis. So I want to make all those points again, just to keep those at the forefront of the court's mind when we address these other crime scene photo issues and closing argument issues. And I'll turn to those now. We submit the trial court acted well within its discretion by admitting these crime scene photos. First, I want to address a couple photos that were not subject to either the pretrial motion or contemporaneous objection. Those are photo exhibits 110 and 111. We submit that those are waived, and defendant really hasn't contested that either today or in his reply brief. So I'll leave it at that. That review of those two photos is waived. Next, I'll move to photo exhibit 112, and we submit that was probative of identity because it showed Miss Enix's body in proximity to a prescription card with defendant's name on it. The question might arise, okay, this crime was admitted by the defendant, so what does identity have to do with it? But I think it also really goes toward premeditation in this case, because I think the record reflects that this prescription card was the subject of some considerable dispute between the victim and the defendant in terms of him spending or misusing some of the funds on this card. And to the extent that that card was left right near her body, it almost functions like a calling card, like something about the misuse of those funds is what led up to this dispute, to this violent encounter, and almost a calling card. I came over here because of this dispute about the use of this money, and that's at least part of the reason I premeditated the killing of you. So I think it also does go toward premeditation. With respect to photo exhibit 115, we submit that was probative of time of death, which again is probative of premeditation because it showed that the victim's makeup had been removed by the time she was murdered, which tended to corroborate that the defendant murdered the victim not long after several phone calls between them abruptly ceased on the night before her body was discovered. We submit that the trial court also reasonably admitted exhibits 139, 155, and 159, which show all the stab wounds, because again, those photos gave life to the astounding number and nature of the 47 stab wounds that again went directly toward premeditation. And really we fall back kind of on the adage here that, a picture is worth 1,000 words. You can have testimony that somebody was stabbed 47 times. You can have an autopsy diagram that shows those 47 stab wounds, but to actually see the variety of location and severity of 47 separate stab wounds, it's part of the evidence. Is it gruesome? Yes. Is it gruesome the fact that somebody was stabbed 47 times? Yes, but that's simply the evidence in this case. And we submit the jury was entitled to see that, and that these photos don't rise to the level of gruesomeness or prejudicial nature that this court has found to be reversible error in other cases. But in any event, even if the court does take issue with some of these photos, again, we point back to that mountain of evidence that the defendant did premeditate this murder, and so therefore he cannot show that these photos more probably than not impacted this jury's verdict. And that is the standard for the non-constitutional harmless error analysis that this court must conduct, even if it finds the admission of some of these photos erroneous. Unless the court has any questions about those photos, I'll turn to the issue of closing arguments. And again, we submit that all the closing arguments in this case but one are waived for either lack of contemporaneous objection or failure to include in the motion for new trial. And I do want to address a legal issue because I think it's well joined in both our brief and the reply brief. And that is this question: the defendant contends that inclusion in his motion for new trial preserves those challenges that were not subject to contemporaneous objection, again, with respect to these closing argument issues. But this court, and specifically 2/3 of this particular panel, have already held in the Booker decision that we cite in our brief, that was not the Supreme Court's holding in Hawkins. The Supreme Court, as opposing counsel and we both acknowledge in our briefs, that the Supreme Court has taken up this issue in Walsh, wherein the same 2/3 of this honorable court reaffirmed, or the same 2/3 of this honorable panel reaffirmed the requirement for contemporaneous objection in order to preserve challenges to closing arguments. But I don't want to just rest on the fact that this court has previously held that. I want to defend the idea that Booker and Walsh were properly decided, were soundly decided. And the basic waiver rule is enshrined in Rule 36, which prevents relief to parties who fail to take whatever action is necessary to prevent or nullify the effect of an error. So a challenge to closing argument in a motion for new trial really does nothing to nullify the effect of improper argument on the jury. A defendant shouldn't be excused for not seeking to nullify the effect of improper closing by way of a contemporaneous objection when there still stands a chance to minimize or nullify that effect actually in front of the jury. And without those contemporaneous objections here for at least a subset of the closing arguments that the defendant contests, we said that those issues are not preserved for that lack of contemporaneous objection. And I just, for the court's information, I looked at this last night. Walsh has been taken up by the Supreme Court, and I believe the state's brief is due in mid-April. So that's kind of where that case stands in terms of that issue being decided by the Supreme Court. And that is the specific issue taken up in Walsh. It was not a general grant by the Supreme Court. It was a grant with respect to that specific issue. So that decision is on the way from the Supreme Court. But beyond that, I'll turn to some of the specific arguments, specifically the 3 closing arguments that the defendant raises in his argument. And I'll start with the one that we acknowledge is preserved. And this is the prosecutor's brief comments about the defendant's relationship with his other daughters. This was not a comment made to be disparaging about the defendant's relationship with his other daughters. The point of these sort of passing statements related to the defense theory of passion, the idea that this little girl, the defendant's daughter with the victim, Brooklyn, that this was the only child in the defendant's life, that his emotional sort of well-being and stability turned on his relationship and his access with the child. We submit that the prosecutor's comments regarding the defendant's other children were merely meant to point out that this was not a credible claim, that his emotional stability depended on this one child. He had other family, and there, it may even be sarcasm, sort of, within the appropriate realm of oratory sarcasm, that the state was saying, well, what about his other daughters? Does he not care about his other daughters? But we submit that was within the realm of proper oratory sarcasm and also responsive to the defendant's argument about his state of passion. With respect to some of the inferences that the prosecutor drew about, what conduct the defendant might have engaged in the apartment after this killing, I'm not going to dispute that it is partially speculative. I think so speculative that it's not based on reasonable inference of what the evidence was. And again, even if the court takes issue with some of that speculation, some of the conclusions that the prosecutor reached, again, we have to turn back to the mountain of evidence against this defendant, the undisputed evidence that he killed this victim, as well as the mountain of evidence that he premeditated that killing, and consider whether or not those particular conclusions and speculations by the prosecutor amount to reversible error, whether they more probably than not affected the verdict, which we submit they did not. And again, that particular argument is waived, and so it's within the context of plain error review, but essentially the harmless error argument is the same. Did it more probably than not impact the verdict, which we submitted did not. And then the final issue I'll talk about is admittedly, it was improper for the prosecutor to encourage the jury to show the defendant the same mercy that he showed the victim. It's been held by this court and possibly even the Supreme Court. It's in our brief if the Supreme Court has held so much, I can't remember. But it was improper for the prosecutor to make that argument. I think we essentially concede that in our brief. But again, this is where we fall back on that mountain of evidence, the admission that basically he committed this killing, as well as the mountain of evidence that he premeditated this killing. Again, this is one of those issues that is waived because it was not subject to contemporaneous objection, but the harmless error analysis is essentially the same, and defendants simply can't show that passing comment at the closing of the state's argument was, more probably than not impacted the verdict to the defendant's detriment. I'm happy to answer any questions the court may have. Otherwise, we just respectfully ask that you affirm the judgments of the trial court. Thank you.
Seeing no questions, we'll hear from you, Mr. Harwell, on your for rebuttal.
Yes, Your Honors, I have three points I'd like to make. One, and this is something I think I tried to make in the reply brief, but is visible again here today. There is a retention in what the state is contending, because at the beginning of the argument, the state agreed, I understood them to agree, that passion on these facts was a reasonable hypothesis, but that premeditation was at least an equally reasonable hypothesis. And under the state's application of sufficiency cases, you don't have to eliminate every reasonable hypothesis to have sufficient evidence of guilt. But I think that is a correct concession by the state, that on these facts, passion is at the very least a reasonable possibility. And the state thinks it's not the better possibility, but it's at least a reasonable one. But then when we turn to the substantive arguments that I've made, the state's response to those arguments in terms of harmless error is, well, they couldn't possibly cause any harm because there's this mountain of evidence against the defendant. And I think that's a tension. And I think the fair explanation, fair view of this evidence is the first one taken by the state. The passion was a reasonable hypothesis on this evidence. And if it's a reasonable hypothesis, then when you have gruesome photographs coming in, when you have a prosecutor urging the jury to seek vengeance against a defendant, it becomes that much more difficult for the jury to rely on that otherwise reasonable view of the evidence.
Well, years ago, Mr. Harwell, we had a case out in California that got quite a lot of attention, and they used the blood of the victims to write Helter Skelter on the walls. Does that show passion, or does that show premeditation?
I think a lot of these things and Manson murders or whatever, I think it can be turned either way. That is evidence that can indicate there's a plan that's being executed. That can also indicate this is someone who is so angry, so upset, irrationally, unjustifiably, but so out of control that the legal requirement of premeditation is not met.
Well, so we generally allow those decisions to be made by the jurors with a lot more information given them, such as unarmed victims, such as motive, which they don't have to prove, but if they've got one, it's acceptable. And if possible revenge is involved, that's a fodder for the juries to consider, is it not?
I think it is. And the point I'm trying to make today is the jury needs to be able to make that decision just by looking at the evidence and without being aroused and inflamed and incited. And here, I think this proof, these photographs, these arguments were really a distraction to the jury, urging them not to look at those facts closely, but simply to decide to wreak vengeance on Mr. Enix.
Now, you do understand we have read your briefs, but I have not personally looked at the photographs at this time.
And the only
We
thing
will.
I say is they are larger and more gruesome in their full extent in the record than the smaller versions I included in my brief. So I would urge the court to look at them completely. The only, I guess I'll skip one point. The final point I want to make is, and again, I think the state has sort of conceded that the closing arguments at least could be viewed as very speculative by the prosecutor. And I think it's important to highlight when a prosecutor makes a series of speculative arguments about this is what happened with the phone, this is what happened with the coffee cup, this is him ironing his shirt calmly and collectedly because he's not actually in a state of passion. When the prosecutor makes those kinds of arguments, as he is standing up as the representative of the state, there's a particular danger. And I think this is mentioned some in the case law. There is a danger that the jury is going to believe he wouldn't be saying that if he didn't have a reason for it. So we maybe haven't heard any evidence about the coffee cup to really know that that's what was going on. But Mr. Allen is standing up and saying that's what went on. We, the jury, sort of think he might know something we don't know. And so I think that is a particular danger of speculation, of overbroad inferences by a prosecutor that can have a real effect on a jury because they trust prosecutor not to be making an argument that is not based in the evidence. That's all I wanted to say on rebuttal. Otherwise, we would ask that you vacate the conviction and remand for a new trial or find the evidence insufficient. Otherwise, I'll rest on my briefs.
Gentlemen, your briefs and your arguments today were very well done. Thank you so much. It is always delightful to have lawyers that appear for us that are prepared, are ready, and have a fully complete knowledge of their case. And you both passed that test with flying colors today. Thank you for your presentation. We'll take it under advisement, and we will adjourn to the call of the next case.
This honorable court is now in recess until 11 a.m.